It's not hoarders.
It's hoarding.
Ow! Oh, I got hit in the butt with a nail. Why is there a shotgun shell?
Okay. Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi. So for today, inshallah, I'm going to talk on the defenses, the defenses under the penal code, and specifically on the defense of mistake, the defense of mistake. Introduction to criminal defenses, the defense of mistake. So the defenses to criminal liability are provided in Chapter 4 of the Penal Code. If you look at Chapter 4, Chapter 4, this is the Penal Code. Chapter 4, General Exceptions. So this starting from Section 76 up until Section 106. All these are the defenses. All these are the defenses under the Penal Code. So this is known as absolute defense. This is absolute defense. This is an absolute defense to criminal liability. What is absolute defense? Absolute defense is that the accused will be acquitted from the criminal liability because of the circumstances under which he acted, the reasons for his acting in such a manner, or factors which suggest that he is not fully responsible for his action. So what is absolute? Why is it absolute? Absolute because he is not guilty of any crime. Once he is able to prove one of the defenses under Chapter 4, then he will be acquitted. He will not be convicted for any offense. This is absolute defense, except of course for the defense of insanity. Then he will put in the mental institution at the pleasure of the Yang di-Pertuan Agong or ruler of the state. In contrast with what? absolute defense in contrast with partial defense. Partial defense, he will still be convicted, but at a reduced offense. For example, if let's say he's able to prove the partial defense of provocation under exception 1 to section 300, then he will still be convicted at a reduced offense of from murder. The offense is reduced to culpable homicide, not multiple murder. So that is partial defense. Absolute defense, you will be acquitted. So partial defense, that is not under our syllabus for this semester. That is for next semester, inshallah. So for now, for today, for this semester, inshallah, we're going to do, or we're going to study on the defense, absolute defense, the absolute defense under chapter 4 of the Penal Code. Chapter 4 ke chapter 6 ni lupa maksudnya. Chapter 4 of the Penal Code. Chapter 4 of the Penal Code. So defense can be divided into two: justification and excuse. Justification, he is allowed under the law. He is allowed under the law to do such act. For example, let's say someone trying to hurt him, or someone trying to steal his property, someone trying to rape her, for example. And then in order to save herself or save his property, then he or she has to retaliate or has to defend himself or herself by counter-attacking the assailant. So in that situation, he or she is justified in doing so. He is allowed under the law to do so. Excuses, the situation is not allowed. He is not allowed to do that. He is not under the law. He's not allowed to do that. But because of his situation, for example, he is insane. For example, that person is insane, for example, or unsound mind, gila. Or a person is under mistake of fact, for example. So in both situations, he is excused by the law. He is not justified. He is not allowed by the law, but he is being excused. He is being pardoned. He's being pardoned. Dia dimaafkan. He is being excused because of the situation, because of his situation. So that is the division of justification and excuses. So the defenses of mistake, necessity, accident. So all these are he is being excused. He is not justified, but he's being excused. But if, let's say, it is a private defense, then he is allowed under the law. He's allowed under the law. He's justified under the law to do such act. Necessity, for example, that is also, he is allowed by the law to do so. Okay, let's look at the difference between justification and excuse was explained in Perka against R. Wilson J. stated, criminal theory recognizes a distinction between justification and excuse. In the case of justification, the wrongfulness of the alleged offensive act is challenged. If it's justified, then the wrongfulness, he said that he is not wrong in doing so. He is allowed by the law to do so. That is not something which is wrong under the law to do such thing. So that is justified. In the case of excuse, the wrongfulness is acknowledged. That act is wrong. Is not allowed to do that. That is a totally wrongful act. But a ground for the exercise of judicial compassion for the actor is accepted. For example, because he is of unsound mind, dia gila. So he is being excused. It is a wrongful act. For example, he killed someone. So that is not allowed under the law. And that innocent people is the victim. He has not done anything wrong, but he's being killed, for example. He is being murdered by the accused. But the accused is of unsound mind. He doesn't know what he's doing. He doesn't know that this is something which is wrong. So he is not justified in doing so, but he is excused because of his condition. So this is known as excuse, in contrast with justification. Thus, the nature of excuse is to personalize the plea, so that while justification looks at the rightness of the act, whether the act is right for him to do so, to do, or whether it is rightful thing for him to do, that is justification. Whereas excuse speaks of to the compassion of the court for the actor, the person doing it, because he is of unsound mind, for example, which must excuse him. It is not fair to convict him because he is of unsound mind. He doesn't know what he's doing. He doesn't know that what he's doing is wrong. Or for example, he is a child, for example, he is at the tender age of 7 years, for example. So when he steals the what called this the property, for example, let's say he steals tricycle, for example, he doesn't have the necessary mens rea because of his age. So this is what they call he is being excused. Or let's say he is he does that under a mistake. For example, he believes that it is a thief coming into his house, so he kicked that person. In actual fact, it is one of the his family members. So in that situation, it is he is not justified, but he is being excused because of a mistake. He doesn't have the necessary mens rea. So this is what they call excuse. In contrast with justified, he or she is allowed to do so. So these are the two division of defense under the penal code. Let's look. So the general exceptions are accident. These are all the exceptions or the defenses under the penal code. Accident, duress, infancy, mistake, slight harm. So let's look at the first topic, the first defense. Why is it this is the first defense? Because it is under section 76. we start from section 76 up until section 106. So the first provision, the first section under the penal code on the defense is section 76. That is the defense of mistake. The primary code provisions on mistake are sections 76 and also section 79. So there are two provisions generally. Generally, the main provisions on mistake are section 76 and also section 79. These sections are virtually identical, meaning they are very similar. They are very similar. The difference is that section 76 concerns a situation where a person under mistake of fact believes he or she was bound under the law or by the law to do such act. So under mistake, under section 76, he believes that he is bound. He is under an obligation. It is compulsory under the law for him to do such act. Because of that, he does that thing. But it is actually wrong. He is under mistake. So in that situation, he is allowed a defense under section. He is allowed the defense under section 76. Whereas section 79 concerns a person who, under mistake of fact, believes he or she was justified by law to do it. Similar to section 79, section 76, the difference is that the accused believes that, or the offender believes that he is justified. Why is justified? He is allowed under the law. Tadi he is bound by the law. It is an obligation for him to do such act. He believes that. Under section 79, he believes that he is allowed. He is justified. Justified here meaning allowed. So anything which is not prohibited by the law, so it is permissible. That is the general rule on law. If there is no law prohibiting such act, then it is permissible. So he believes that he is allowed under the law. He is justified under the law to do such act. And he does that. In actual fact, is wrong. So that is what they call a mistake. For example, let's say he sees some certain thing move in his backyard. He believes that it is a monkey, for example, and he shoot that supposed to be monkey. But in actual fact, it is a human being, for example. So it is a mistake. He believes that, he thought that is a monkey, but in actual fact, it is a human being. So it is a mistake. So can he kill a monkey? Of course, there is no law prohibiting him from killing monkey. Therefore, he is allowed under the law. He is justified under the law to do such act. He believes. But in fact, it is not a monkey, but a human being. So it is a mistake. So he, in this hypothetical situation, he is justified. He believes that he is justified under the law to do such act. Because of that, he may be able to rely on the defense under section 79. Section 79. Since section 76 and section 79 are found in chapter 4 of the Penal Code, they apply to offences within and without the code. What is within and without the code? Meaning, these defenses, these two provisions are applicable to all the offences under the Penal Code. So any offences, for example, the offence of murder, for example, or the offence of theft, for example. He believes that it is his motorcycle, so he ride the motorcycle, bring it home, for example. So he is under mistake of fact. So that offence of theft or offence of murder, he kills someone believing that it is a monkey, for example. So that is, or thinking that it is a monkey. So that is what they call under the Penal Code. The offence of murder, the offence, any offences under the Penal Code, under the Penal Code. And also without the code. Why is it without? Meaning the other offences. For example, Dangerous Drugs Act. For example, Dangerous Drugs Act. He doesn't know that it is what they call, but that there is a that it is some sort of what they call a drug, for example. He doesn't know that it is some sort of prohibited drug, for example. But of course, there are exceptions to this because of the presumption under the law, and that is another thing. But generally, it is also applicable to other statutes on criminal law. And then, unless excluded by the statute, unless it's stated in that particular statute that provision is not applicable. So if it is so, then that this provision, section 76 and 79, will not be applicable. If it is not stated in that particular statute, then these provisions, these two provisions will also be applicable, even though this provision is stated under the Penal Code, but it is also applicable to other statutes. That is what is meant by within and without the code. Within the code, offences within the code, and offences in other statutes. The term bound by law under section 76 involves the actor some legal duty to undertake conduct, as shown by the illustrations under section 76 of a soldier who is lawfully ordered by his superior to shoot, and of a court officer who is ordered by the court to arrest someone. The term justified by law under section 79 only requires the actor's conduct to have been lawful. For example, a soldier who is instructed that he may shoot if a mob refuses to disperse, or a court officer who is told that she may restrain a witness who becomes unruly in court. Both sections expressly declare that mistake of law is not a defense, so only a mistake of fact. So what is a mistake of law? For example, let's say he brings marijuana, for example, and then but he believes that because he has been living in a certain country, in other countries for many years. So when he comes home and he used to take marijuana, for example, this is an example, and that marijuana is allowed in that particular country, in the country that he lives. Later on, he returned home, Malaysia. He doesn't know that it is not allowed in Malaysia. So he takes that. So in that situation, he under a mistake, doesn't know there is a law saying that it is wrong to take drugs or to take marijuana, for example. If that is the case, he may not be able to rely on the defense under Section 79. Because why? Because that is not a mistake of fact. That is a mistake of law. Mistake of law is not a good defense. So let's look at the provisions of the Penal Code. The provisions of the Penal Code. Section 79 says, this is the provision of the Penal Code. If you look at the provision of the Penal Code, this is a Penal Code, let's see. Okay, this is a Penal Code. Nothing is an offense. Chapter 4, act done by a person bound or by mistake or fact, believing himself bound by law. So this is the provision, Section 76, and this is the illustration, two illustrations. So this I copy and paste from the provision of the Penal Code, the slide totally. Okay, let's look at my slide. So this is I copy and paste from the Penal Code. So the section, Section 76 says, nothing is an offense. So when the Penal Code says nothing is an offense, this is an absolute defense. It is not an offense at all. So this is an absolute defense. Nothing is an offense which is done by a person who is or who by reason of mistake or fact. So if you look here, one of the conditions, one of the what they call the condition or the prerequisite before that person can rely on the defense of mistake is that it must be a mistake of fact and not a mistake of law. So it must be a mistake of fact and not by mistake of law. So that is the first condition. The first condition is that it must be a mistake of fact and not mistake of law. Example I've given to you just now. I've already give you the example of a person doesn't know that the law prohibit him from doing such thing in Malaysia. So if that is the case, then he is not allowed the defense because that is the mistake of law, not a mistake of fact. Mistake of fact, for example, he believes that when he shoot to the bush, he believes that it is a monkey, for example. In actual fact, it is a human being. So the fact is that it is a human being, not a monkey. So that is a mistake of fact. Fact that it is a monkey or fact that it is a human being. So this is mistake of fact, not mistake of law. The law is very clear. Killing a monkey is allowed. Killing human being is against the law. The law is very clear. It's not mistake of law. It is very clearly a mistake of fact. If that is the case, then he is allowed under under Section 79. That is under Section 79. In good faith, that is the difference between mistake of fact and mistake of law. And the second condition is that in good faith, he must have acted in good faith. He must act in good faith. Believes himself to be bound by the law. Number three, he believes that he is bound by the law to do it. He is bound. What is bound? Bound is compulsion, compulsory, obligation. It is an obligation for him. It is compulsory for him. So that is bound by the law. Let's look at the examples to make it easier for you to understand. A soldier fires on a mob by the order of his superior officer. A soldier is ordered by his superior officer in conformity with the commands of the law. A has committed no offense. A, an officer of a court, being ordered by court to arrest Y. A, as an officer of court, being ordered by that court. When he is being ordered by the court, so he is bound. He is bound by the law. It is an obligation for him under the law to comply with the order because it is an order by the court and that order is made under the law. Being ordered by the court to arrest Y is being ordered by the court to arrest Y. And after due inquiry, believing Z to be Y, so he arrests Z under a mistake. So that is a mistake. So the mistake is a mistake of fact, because he believes that Z is Y. So that is a mistake of fact, mistaken identity, not a mistake of law. The law is very clear. He is what they call required under the law. It is an obligation for him under the law to arrest Y. So it is a mistake of fact. So but he has done it under a mistake. Instead of arresting Y, he arrests Z. So, so it is a wrongful arrest. It is wrong for him to do that. But because he is under mistake, that he believes that he is bound by the law. He is bound by the law. He believes that he is bound by the law to arrest that person. So he may be able to rely on the defense under Section 76. So this is the examples of the defense under Section 76. That he believes that he is bound by the law to do such act. So three things must be complied with, must be fulfilled. Three requirements must be fulfilled. Number one, it must be a mistake of fact and not a mistake of law. Number two, he must do that in good faith. And number three, he believes that he is bound by the law to do such thing. It covers situation where a person under a mistake of fact believes he is bound by law to do an act, or he believes that he is under an obligation to do that act. For example, superior orders. When a soldier, for example, is being ordered by his superior, so he believes that he is bound by the law to comply with the order, with the command of his superior. Or a police officer, for example, he's ordered by his superior, for example. So he believes that he is bound by the law to follow the order or to comply with the order of the superior. So this is situations whereby he may be able to rely on the defense under this provision. Now let's look at Section 79. Section 79 is actually similar to Section 76. If you look at Section 79, this is Section 79. If you look at Section 79, this is also, I take this also from the Penal Code. This is from the Penal Code. This is Section 79, act done by a person justified or by mistake of fact, believing himself to be justified by law. This is Section 79, and then the illustration. Only one illustration. So this, if you look at this provision, I copy and paste, I put it in my slide. Let's look at my slide. This okay, this is the what I call. This is Section 79. I take from the Penal Code. This is Penal Code, and I take this Penal Code. I put it into my slide. So don't worry about this. Everything is taken word by word from the Penal Code. So let's look at Section 79 of the Penal Code. Similar, very similar to Section 76. Nothing is an offense. So when Penal Code says nothing is an offense, this is also an absolute defense. Meaning that once the offender or the accused has been able to prove the what we call the defense under Section 79, then he will be acquitted. He will be acquitted. He will not be convicted for any offense. Okay. Nothing is an offense which is done by a person who is justified by the law. Or that is, of course, that is what you call the normal situation. If he's justified by the law and he's allowed by the law, that is not an offense. Nothing is an offense which is done by a person who, by reason of mistake of fact, this is the defense. The second part is the defense. If it is justified by the law, then it is not an offense at all. Nothing is an offense which is done by a person who, by reason of mistake of fact, He is under mistake of fact and not mistake of law, similar to section 79. In good faith, he must also act in good faith. So that is similar to section 76. The difference here is here. In good faith, believes himself to be justified by law to do it. He believes that he is justified by law to do it. He believes that he is allowed under the law to do such thing. For example, let's say someone, let's say the monkey tadi, he sees something moving in his backyard, believing it is a monkey, and he shoot at it. In actual fact, it is a human being. So he is under mistake under section 76, 79. It is a mistake of fact. It is a mistake of fact. He believes that he is justified under the law to do such thing, to kill that thing, because he believes that it is a monkey. So that is a mistake under section 79. Another example, let's look at the illustration. A sees Z commit what appears to A to be murder. He sees Z attacking someone. For example, let's say he attacks or he kills. Z kills someone. For example, let's say Z kills S, for example. So it appears to A that Z is committing or Z is trying to commit an offense of murder under the penal code. A, in the exercise to the best of his judgment, exerted in good faith, of the power which the law gives to all persons of apprehending murderers in the act. Meaning that if, let's say, it is an offense, any person, any good citizen, may do whatever it is necessary to apprehend the murderer and bring that person to the police station, because it is because that is allowed under the law. It is allowed to apprehend or to citizen arrest that person and bring that person to the police station. So he arrests or he apprehends Z. But in actual fact, Z has not committed an offense. Z is doing something which is right. For example, let's say Z was acting in self-defense. For example, let's say S tadi was trying to rape her. Let's say Z is a girl. S was trying to rape her. So in order to save herself from being raped, she killed that person. So she has not committed any offense. A here, even though he has done something which is wrong, arresting someone or apprehending someone who has not committed any offense, however, he is allowed under the law, he is permissible under the law, or he is able under the law to rely on the defense under section 79. So this is an example how a person may be able to rely on the defense of mistake under section 79. So in this example, A believes that in good faith that he is permissible or he is justified under the law to apprehend Z. But that is a mistake of fact. It is a mistake of fact. So because of that, he is able to rely on the defense under section 79. An act done by a person who, under mistake of fact, in the belief that he is justified by law to do so. The rationale for recognizing mistake of fact as a defense is that a person who, as a result of mistake of fact, in good faith, believes himself or herself to be bound or justified in doing the act is not criminally blameworthy. So that is justification, because it is what they call, it is not fair to him, because he is acting, if you look at all the situations, the examples just now, he believes that he is bound by the law, or he believes that he is justified by the law, or she believes that she is justified, she is allowed, permissible under the law to do such act, but is allowed to do such act. So if that is the situation, if let's say he believes that he is doing something which is noble, for example, trying to apprehend a murderer, for example, in order to bring that particular person to the police station, if we convict that person, then it will not be fair to him, because he has acted honestly for the good of the society, but under a mistake. So that's the rationale for having this kind of defense. It is not fair to convict a person who is not criminally blameworthy, who has no intention to commit a crime, who has no guilty mind, who is not blameworthy, who is not criminally blameworthy. So let's look at bound by law under Section 76 of the Penal Code. There is no definition of bound. The meaning of bound is not defined under the Penal Code. So if you look at concise Oxford Dictionary, constraint, bound is defined as constrained or required by law or under a duty. A person who is under a duty, so that is bound. He is under duty, he is required by the law. So that is bound. It is a legal compulsion imposed on him. So that is bound by law. It's a legal compulsion, meaning he is legally bound to do that. He is under the law. It is an obligation for him. If he doesn't do that, then it is something which is wrong on him. It is something which is against the law for him not to do that. The case of Ni'man Khan, to entitle the person to claim the benefit of Section 76, it is necessary to show the existence of a state of facts which would justify the belief of good faith that the person to whom the order was given was bound by law to obey it. Okay, let's take a break of 5 minutes. Yeah, take a break of 5 minutes. Okay, let's continue. The defense of a superior order may encompass situations where the orders are lawful and also unlawful. So under section 76, this is the situation where a person is allowed by the law is being excused under the law if he believes that in good faith he believes that he is bound by the law to do that act. So if let's say he's bound by the law, he believes that he's bound by the law because he is being ordered by his superior. So this order by the superior, for example, let's say a soldier, for example, his superior order him to do certain things, for example, or a police officer, for example, he's being ordered by his superior, police officer, inspector, for example, is ordered by senior assistant commissioner, his superior, senior assistant commissioner to do that thing. So this order by the senior assistant commissioner of the police of the police or army officer of police, for example, may be two types of order. The order may be a lawful order. It is a rightful order. He's allowed under the law to make such an order. So that is a lawful order. The second situation, the order is unlawful. The order, he has made that order, but in actual fact, that order is against the law. So if the order is lawful, then there is no question about that, and it is not a problem. If it is he is being ordered by his superior and the order is lawful, but then he make a mistake, for example. So in that situation, he is allowed under section 76. He is being excused under the law through section 76. But the problem here is that if it is the order is unlawful, let's say the order is unlawful, he is ordered to kill, let's say, an innocent citizen, for example, and he does that because the order is made by his superior. So will he be able to rely on the defense under section 76? So let's look. This is the issues. These are the issues that need to be determined. So a soldier obeying a superior order is under some form of compulsion. He is obliged to obey, but there are two competing interests. We, per the law, must balance these two competing interests. Number one, in the interest of maintaining discipline, and they should be protected from criminal liability when they are simply obeying the orders. So number one, the first interest is to make sure that the subordinate officer to obey the order of the superior, the rightful order of the superior. Why is that so? Because we want to maintain discipline. It's very important for the police force and criminal and armed force to be well disciplined. If they are not disciplined, then how can we maintain? How to make sure that they do what they should do? So that's why it's important for the law to ensure that they must comply with the order of their superiors. That's why this is very important in what we call in police force, in armed forces. Because why is that so? Because to maintain discipline. That's why if you look at the what we call the police force, the armed forces, you see that there are many ranks. There are many ranks, subordinate ranks, superior ranks, kan? For example, let's say police or the police force, police officer, for example. We have starting from constable, kan? Constable, and then lance corporal, and then corporal, and then sergeant, sergeant major, lagi apa lagi? Tak ingat dah. Okay, then inspector, that is a lower rank officer, and then inspector, then we have assistant superintendent, I said assistant superintendent, and then deputy superintendent, superintendent, assistant commissioner, deputy commissioner, police commissioner. Kan, so many ranks. Why are there so many ranks? In order to make sure that they are the higher rank can make order to the lower rank, to the lower ranks officer. So this is to maintain discipline. Who should take command? Who should be in command? That is important to maintain discipline. That is the one of the interest. The interest is to maintain discipline. So we must not disrupt this. We must allow, or we must not. The law should not interfere in this situation. That is the first interest, to make sure that the officers to maintain their discipline. Number two, if they do not obey, they are subjected to military punishment. If they do not obey, then if they armed forces, they are subject to military punishment. They may be called to the court martial, for example. If let's say he is under the police force, that he may take the police force may take disciplinary action against him if he doesn't comply with the order of the superior, and he may also not be will not be allowed to be promoted, for example. And number three, but it can be argued the second interest, that is the first interest, to maintain discipline. The second interest is that those who has caused the death of innocent people should not be protected on the reason of the superior orders. The second interest is this interest of the public. If let's say he is allowed, if the subordinate officer must comply with the order of superior, even though that order is unlawful, for example, to kill a good citizen, for example. So it will not be fair to the public, to the citizen, to the innocent people. So these are the two conflicting interests. Number one, the interest of maintaining discipline among the forces, and the second interest is to protect the public. So these are the two interests, the two competing interests. We must balance between them. Balancing between the interest of making sure that the subordinate officer complying with the order of the superior in order to maintain discipline, and the second interest is the interest of the public to make sure that nobody is being treated unfairly. So what will happen if the order is unlawful? If the order is lawful, there is no question about that. What if the order is unlawful, meaning the superior officer giving an order which is against the law, and that subordinate officer comply with the order of that superior? Can he later on, can the subordinate officer later on rely on the defense under section 76? That is the question. Because he's merely doing that because he is complying with the order of the superior. The defense of superior orders is a compromise between two extreme positions, provided that the order is not manifestly illegal. So according to the case of Cayley and Bell, if the order is manifestly illegal, what is manifestly illegal? On the face of it, it is illegal. It's very clear that it is illegal. For example, he is ordered, for example, a soldier is ordered to kill innocent people, to kill the innocent, a child, for example. So it's very clear that the order is unlawful. But if let's say he complies with the order of the superior, then he will not be able to rely on the defense of mistake under section 76. If later on, it seems that the order has been made by mistake, or he has been he believes that the order is something else, for example. So he will not be able to rely on the defense under section 76 if the order on the face of it is clearly illegal. If it is a lawful order, then there is no question about that. Even if it is murder. This can be seen in the case of state of Bengal and Shu Mangal Singh. 2 persons were killed during the civil disturbance where the Deputy Commissioner of Police ordered the accused to open fire. The court acquitted the accused on the ground that the orders were justified. And the accused was bound to obey the lawful order of his superior. So if it is unlawful order, if the order is unlawful, the consequence of the conduct will depend on whether the person who obeyed the order committed the harm. Either he, by mistake, believes the order is lawful, or he is aware that the order is unlawful, but he still obey it because he is scared of being penalized by his superior, for example. So these are 2 situations. Number 1, he doesn't know. He believes that the order is a valid order. The order is a lawful order. That is the first situation. The second situation, he knows that the order is unlawful, but he is scared of being punished or being penalized by his superior. So he still obeys the order, even though he knows that the order is unlawful. So these are the 2 situations. So what will be the effect? If it is under the first situation, if the accused obeys it by mistake, believing that the order is lawful, then he is entitled for the protection under Section 76 on the condition that the order is not on the face of it illegal. The order doesn't seem to be illegal. And he believes that the order is lawful. So if that is the case, then he may be able to rely on the defense under Section 76. This can be seen in the case of Shu Mangal Singh against the state of Calcutta. What if the order is unlawful? If the order of the superior is unlawful, then he may not be able to rely on, and he knows it, the order is unlawful and he knows it, then he may not be able to rely on the defense under Section 76. He may try to rely on the defense under Section 94. Section 94 is on duress. He is being forced to do that thing. But it is very difficult to be able to rely on this defense of duress, because under the defense of duress, the threat must be of instant death. It is usually the threat by the superior officer is not of instant death. Usually it is merely by making life difficult for that particular person or the subordinate officer. So that is not allowed under Section 94. We'll see later on when we reach to that stage of discussing Section 94 and the defense of duress. So let's look at justified by the law. This is another situation. Section 76 is allowed. He is what do you call? He is obliged under the law. He is under an obligation under the law. He must obey the law. He should obey the law. He is bound by the law. That is under Section 76. Section 79, he is justified by the law. He believes that he is allowed by the law. He is justified by the law to do such act. The act must be done in accordance with law, or the act done in obeying the law, or in conformity with the law. It covers the situation where a person mistakenly believes that he or she is justified by the law to do such act. There being no code definition of what is justified by law means, what justified by law means in relation to Section 79, the courts have held that an act which is not illegal is justified by the law. So what is the meaning of justified by the law? There is no definition in the penal code. But generally from many cases, it can be seen that the meaning of justified by the law is that if there is no law making that act as an illegal act, then that act is justified by the law. One of the cases is the case of Abdullah against Arab. So elements of mistake of fact, the defense of mistake of fact under section 76 and also section 79 require the accused to prove on a balance of probabilities the following elements. These I already explained. Number one, he or she had been induced by a mistake to commit the criminal act in question. Number two, the mistake was one of fact and it is not mistake of law. Number three, the accused mistakenly believed that he or she was bound or justified by law in doing the criminal act. And lastly, number four, the mistake was believed by her or him in good faith. So these are the requirements or the elements of the defense under section 76 and also section 79. So these are the things. Yeah? So what is the meaning of mistake? Mistake is not defined in the penal code. The penal code doesn't give any definition of mistake. So because of that, we have to look at the our textbook. In our textbook, Gower, Hari Singh Gower, Penal Code of India, define mistake as a mistake of fact may be due to chance, negligence, stupidity, because he's stupid, for example, or prearranged, or even superstition. He believes in superstition. He believes that it is a ghost. He is stupid. Because of that, he believes that that thing is a ghost. And then, is there any law prohibiting someone or anyone to kill a goose? There is no such law again. Because there is no law prohibiting someone to kill a goose, then he is justified in killing a goose. But in actual fact, it is not a goose. It is a human being, for example. So he is under mistake of fact. So then, in that situation, he is allowed under the law. So this is the definition given by Hari Singh Gower, Penal Law of India. A mistake of fact may be due to chance, negligence, stupidity, or even superstition, but it must not be due to designs, prearrangement, or preconcert. Designs, prearrangement, or preconcert is what we call the plan act, arrange act, arrange beforehand. A mistake of fact consists in a unconsciousness, ignorance, or forgetfulness of a fact, past or present, material to the transaction, or in the belief of the present existence of a thing material to the transaction, which does not exist, or in the past existence of a thing which has not existed. So this is the definition given by another Indian writer known as Ratan Lal. Ratan Lal Dirajlal. He's very famous on criminal law. I think the book sekarang ni berapa, tak tahu dah berapa dia punya edition. 100 something good edition. So let's look at the cases. Very interesting cases. Let's look at the cases explaining the situations whereby the defense of mistake may be applicable. First case, Waryam Singh against Emperor. The accused killed a man with several blows from a stick. Was acquitted because he believed in good faith at the time of attack that the deceased was not a human being but a ghost. So the accused in this case, he saw something moving. He believed that it was a goose. He thought that it was a goose. So he killed that goose. That's supposed to be goose. In actual fact, it was the deceased. It was the victim. He was not a goose, but a human being. So in this situation, the court allowed the accused of the defense under section 79 because he believed in good faith that he was justified in killing that particular goose. So this is a situation, the first example of the situation whereby a person is allowed the defense of mistake. Another case, quite similar, case of Bodakwi against King Emperor. In this case, the accused was acquitted due to the fact that she thought by a mistake of fact that she was justified in killing the deceased from whom he did not take to be a human being, but an evil spirit which ate human beings. So in this case, in the case of Bodakwi, she thought that it was a ghost because that it was her relative, yeah, her husband's relative. She thought that it was a ghost because that thing was dancing naked, yeah, what do you call, and with a broom. So she thought that it was a ghost. So she killed that supposed to be ghost. In actual fact, it was her husband's relative. So because of that, the court found that she was under a mistake of fact and believing that it was a ghost and believing that she was justified in killing the ghost, the supposed to be ghost. Because of that, the court allowed her the defense of mistake under section 79. Another case, the case of Chirangi against the state of Nagpur. In the case of Chirangi against the state of Nagpur, in this case, the father was having some sort of fever. He was having some sort of health problem. He was having delirium. Delirium is something or some sort of imagining things, that is hallucination. He was imagining things because of the the fever. Because of the fever was too high. Because of that, he was imagining thing. He imagined certain thing which was not, which did not exist. So he was hallucination, we call that. He was under hallucination. So in this case, he saw his son, he looked at his own son, and what he saw was a tiger. He thought that it was a tiger because of the fever. He thought that it was a tiger, not his own son, a 12-year-old son. So he killed his own son, his 12-year-old son, because he saw that child as a tiger. So the court found that he was under a mistake of fact. He believed that it was a tiger. So it was under a mistake of fact, believing that he was justified in doing such a, because he is allowed to kill that tiger because he may, if it is a real tiger, he was allowed to do that because it may endanger his life. But in actual fact, it was not. It was his own child. So the court allowed him the defense under section 79 because he was honestly under mistake of fact, believing that the child or his own son was a tiger. As a tiger. However, in the case of Sulong bin Nain, the accused was apprehended with 2 hand grenades and charged with the offense of carrying arms under section 3, subsection 1 of the Public Order and Safety Proclamation. This is during the the Order of Public Order and Safety Proclamation because of the communist era. That's during that time. So he brought with him, the accused brought with him 2 hand grenades. And then he tried to rely on the defense under section 79. But the court did not allow him the defense under section 79 because the court found that he was not under mistake. He knew that he was carrying hand grenades. He knew that he was carrying a hand grenade. So it was wrong under the law. Because of that, the court did not allow him the defense of mistake because he was not under mistake. He knew that he was carrying hand grenades. Another case, the case of Arumugam and another against R. The 2 appellants and 3rd person were members of police force who were convicted of an offense under the Foodstuff Movement Restriction Order for moving rice without permit. Under the law, during that time, if a person wants to, even today I think, if one person certain amount of rice, they must have the permit to do so because it is under control. The government, the state must control this necessary foods, the essential foods, rice. So in this case, they said that they were being ordered by their superior, their police officer. So they are being ordered by their superior. So they believe that they are bound to do such thing. The appellate court quashed the conviction on the ground that they had mistakenly believed the third person was acting bona fide. So what is one of the requirements under Section 76 and also Section 79 is that the act must be done in good faith. So what is good faith? Good faith is defined under Section 52 of the Penal Code. Section 52 says nothing, the meaning of good faith is nothing is said to be done or believed in good faith, which is done or believed without due care and attention. So good faith meaning under Section 22, a thing which is done with due care and attention is said to be done in good faith. So there are cases on this, on good faith. In the case of public prosecutor against Tunku Mahmud Iskandar, to satisfy the court of good faith, a person must show that he acted wisely and that he had reasonable grounds for believing that he ought to do what he did. So that is the meaning of good faith according to public prosecutor against Tunku Mahmud Iskandar. Another case, the case of Gopal and Awang bin Mona. In this case, the court defined a good faith to include due inquiries and implies not only an upright mental attitude, but also clear conscience and that ordinary prudence has been exercised according to the standard of ordinary person. And another case, the case of public prosecutor against Teo Eng Chan, defense will be rejected where there is no exercise of due care and attention in committing of the mistake of fact. He must do that with due care and attention. If he doesn't do that with due care and attention, then he has not acted in good faith, because Section 52 has defined good faith as done with due care and attention. Another requirement, it must not be a mistake of law. So if it is a mistake of law, then he may not be able to rely on the defense of mistake. Ignorance of the law is not an excuse. If he ignore the law, if he doesn't know the law, it is not an excuse. This was held in the case of Nawaraya against Wong Hao Wei. There is a difference between mistake of law and ignorance of the law. Ignorance implies total want of knowledge in reference to the subject, but mistake admits knowledge but made a wrong conclusion. So this is the difference between ignorance of the law and mistake of the law. Mistake of law ordinarily means mistake as to the existence of any law on a relevant subject as well as to what the law is. This was held the case of the king against Tusti Pada Mandal and others. So mistake of law can be divided into, number one, ignorance as to the existence of the law. He doesn't know that there is such a law. So that is ignorance of the law. He doesn't know that there is a law prohibiting us from doing certain things, for example. So that is ignorance of the law. Or he knows there is such a law, but he interprets the law wrongly. So this is the second situation. The first situation, he doesn't know such a law exists. The second situation, he knows that there is such a law, but he interprets the law wrongly. Ignorance as to the existence of the law, there is an exception to the maxim ignorantia juris non excusat, or ignorance of the law is not an excuse. That is, if he could not possibly have known the existence of the law he had offended. If there is no way for him to know the law, to know that there is such a law, then he may still be able to rely on the defense of mistake. This can be seen in the case of Lim Chin Ai against R. Lim Chin Ai against R, the accused was charged with the offense under the Immigration Ordinance 1952 of unlawfully remaining in Singapore. So in this case, he was charged with the offense of under Immigration Ordinance 1952 of unlawfully remaining in Singapore. He should not stay in Singapore, but he stayed in Singapore more than what was allowed. The relevant minister had made a prohibition order in respect of the accused, because under the law, under the Immigration Ordinance, the minister in charge with the immigration, yeah, he may make an order to prohibit someone from entering into Singapore. And the relevant minister had made such an order in respect of the accused. So he has prohibited the accused from entering into Singapore. However, the accused had not been aware of the order. The order was not given to him. So he did not know that there was such an order, because it was a very specific order ordering him not to enter Singapore. So he was not told of such an order. Because of that, he entered into Singapore. On appeal to the Privy Council against the conviction, the Judicial Committee held that the maximum of ignorance of the law is no excuse, cannot apply to this case, as the order was not published to enable a man by appropriate inquiry to find out what the law is. So in this case, the court held that even though there was such a law, such an order made by the minister, so it becomes a law, but the law was not published. So the law was not published, it was not informed to the public. Because of that, the court held that it was not because it was not a valid order. It was not a valid order. It was a valid order, but it was not possible for him. It was not possible for him to know there is such a law. Furthermore, he was not staying in Singapore. He was staying in Malaysia. So when he entered into Singapore, he did not know that there was such an order made by the Singapore government, by the Singapore minister. Because of that, the court held that he was still allowed the defense of mistake, even though it was a mistake of law. It was a mistake of law in Singapore and he was staying in Malaysia. So there was no possibility for him, and the law was not published. So there was no possibility for him to know the existence of such law. So it was not fair to convict him. And then another case, the case of PP against Ho Cheh Yu. In this case, the accused persons were charged with importing pianos, which being the product of South Africa, were then by law prohibited goods. So in 1980, it was prohibited. The government of Malaysia prohibited the Malaysian from importing pianos from South Africa because of the the apartheid. South Africa had the policy of apartheid rules, implemented apartheid rules. So Malaysia was against that. So they made such a law. They made a law to prohibit anyone from importing any goods from South Africa. So in this situation, the accused imported the piano into Malaysia, the piano from South Africa into Malaysia against the law. The court held that the rule that ignorance of law was not a defense should not be extended to the case where the accused could not reasonably have known the existence of the law he had offended. However, in this case, the appellants had failed to prove on the balance of probabilities that they could not have reasonably known the prohibition against the importation. Thus, the conviction was upheld. So the court held that he was not allowed the defense of mistake. Even though his argument was that he did not know that there is a law prohibiting anyone from bringing products of South Africa into Malaysia. He did not know that there was such a law, but the court found that it was a mistake of law and not a mistake of fact. He should have known the law in Malaysia because he was a Malaysian. So because of that, the court did not allow him the defense of mistake under section 79. Another situation is mistake as to the law's interpretation, as to the interpretation of the law. Mistake based on the wrong interpretation of law is also a mistake of law and not a good defense. So if he made a mistake as regards to the interpretation of the law, that is also considered as mistake of law and not a mistake of fact. Because it is a mistake of law, you may not be able to rely on the defense of mistake under section 79. This can be seen in the case of Sankoff and Holford. In this case, the appellant was charged with having in his possession certain obscene books for the purpose of sale. his defense was that though he knew of the contents, he knew that there was some naked picture of a woman, for example, just example, in that book, but he did not believe that the contents were obscene. It was he believes that the content was an art, for example. We did not know. He knows that it is wrong to bring or to sell pornographic material or obscene books. But he believes that the book that he's selling is not an obscene book, but is an art book of art, for example. So, however, the court rejected this argument. The court held that mistake as to the interpretation of the law, as to the interpretation of what is obscene book, what is not obscene book, that is mistake as to the interpretation of the law, is also a mistake of law. Because of that, he was not allowed the defense of mistake, because it was a mistake of law and not a mistake of fact. And lastly, the burden of proof. The burden of proving Section 79 is upon the accused. I mean, if let's say the accused try to rely on the defense of mistake, saying that he is under mistake of fact, believing himself to be justified under the law to do such an act, then he must prove that. He must prove that he is under such situation. And the courts presume the absence of such circumstances until it is proved. The presumption by the court is that he is not under a mistake unless he is able to prove that he is under a mistake. So that is all under the defense of mistake. You have any question? Anything that you want to ask? Anything that you need further clarification, further explanation? Boleh faham?
Faham, sir.
Ya, tak ada ya? Okay, tak ada. We end our class today. Selamat Hari Raya, because today is the last day before Hari Raya. Last class for us before Hari Raya. So see you after the Hari Raya, insyaAllah. And from that week forward, insyaAllah we will do the what they call the Google Meeting tutorial 2. So it will be both the lecture and also the Google Meeting tutorial. But we'll see if you have anything that we need to discuss, then we do it for.
It's not hoarders.
It's 40 minutes, but if nothing much to discuss, then perhaps 20 or 30 minutes may be sufficient. Okay, that's all for today. I see you after the Hari Raya break, insyaAllah. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, sir.
Thank you, sir. Sampai jumpa.
Thank you, sir.